Can I lose my trademark rights if I don't use my trademark? Yes, absolutely. If you don't use your trademark, you are liable to lose your trademark rights. Let's think about this for a second. Now, remember that the whole reason why we have trademarks in the first place is to allow people who are trademark owners to use the trademark to distinguish their goods and services from other people's goods and services. And in order to do that, you have to be producing goods and services upon which you use your trademark or with which you use your trademark in the case of a service. Because services, remember, they're not tangible. It's not like this pen where I can put the trademark on the actual product itself. It's not like, this hand cream, okay, where it says Trader Joe's, that's the trademark, ultra moisturizing hand cream. So I can't put a trademark on a service because a service is intangible. It's not a thing that I can put a trademark on. I can, however, use the trademark in conjunction with the offer of the service or in conjunction with some kind of billing or invoicing for the service. That would be considered trademark use for services. Now, if you don't use your trademark, two things: you can't get a trademark in the first place without showing use. There's an exception to that, but I'm not going to talk about it here. But in general, when you apply for a trademark, if you apply at some point in the trademark process, you have to show the trademark office how you're using the trademark and what the goods and services are. And you have to show them that there is some link between the trademark use and the offer of goods and services so that the trademark examiner can see how you're using the trademark and what goods and services you're using the trademark in conjunction with. Now, if you're not offering goods and services, it's not possible for you to show trademark use. Why? Because you don't have anything that you're offering in conjunction with the use of the trademark, right? It's self-evident. Now, there are some things that people think are trademark use that are not really trademark use. For example, merely having a URL of the trademark, like Trademark.com, that's not, without more, necessarily trademark use. Other things, having a business LLC in the trademark name, without more, is not trademark use. What else? Merely mentioning the trademark on a website that's not offering goods or services is also not trademark use. So merely mentioning the trademark is not trademark use. So what is trademark use? Trademark use is things like using the trademark on a web page that offers goods or services. Trademark use is, in the case of a service, having an invoice that has the trademark on it that is billing for the goods and services. That's considered trademark use. Advertisements for goods or services can also be trademark use. So there are lots of things that are trademark use. Oh, what else? Point of sale displays. So when you go up to the cash register, you may see, for example, a display of some small item, maybe like this pen. And the display in which the pens are stuck has the trademark on it. That is considered a point of sale display. Another thing that's a point of sale display for goods, things like liquid goods, like maybe beer, are when you go to the bar and there is an array of taps behind the bar that have the trademark on it. Maybe it's the name of the beer. That is considered a point of sale display, and things like that are trademark use. Things like putting the trademark on the packaging for the goods is considered trademark use, or on a label for the goods, that is considered trademark use. So there are lots of things that are considered trademark use, and your trademark attorney can advise you and help you prove your trademark use during the trademark application process. Can you lose your trademark rights if you don't have use? Yes, you can. Remember, the only reason why we have trademarks is to distinguish your goods and services from other people's goods and services. And if you're not offering goods and services, then there's no reason for you to have a trademark. That said, there are circumstances under which, there's something called excusable non-use. So you may be not using your trademark, but it's for some reason that is out of your control and is temporary. What's an example? So let's say that you manufacture a product, and that product relies on a piece that's only available in one factory, and that factory burns to the ground. So you have no more ability to source this part that you need for your product, and you have to wait until the supplier builds the factory again, or until you can get that product or that piece from some other factory. That time period during which you're not selling the product or using that trademark would be considered excusable non-use. Why? Because you want to use the trademark. It's just not possible because you can't get the part that you need in order to manufacture the product that bore the trademark in the first place. So that would be an example of excusable non-use. So in general, if you don't use your trademark, you are liable to lose your trademark rights. But like everything else, there are some exceptions, and excusable non-use is an exception to the rule that you must use your trademark to continue having trademark rights. I'm Angela Langlotz. I go live here to talk trademarks and copyrights. If you have questions, drop them into the comments below. I'll answer them on a future live. You can find me on Facebook. I'm on Instagram, and I'm also on YouTube, where I have more than 600 videos about trademark and copyright law. So find me there. I'm also online at TrademarkDoctor.net.